Under the best evidence rule, a party generally must produce the original of a writing, recording, or photograph to prove the document's contents. But what about computerized data? Does the best evidence rule require a printout or other readable form of such data? The United States Court of Appeals for the Ninth Circuit considered this question in United States v. Bennett. On January 27, 2000, a U.S. Customs officer saw Vincent Bennett's boat near the United States and Mexican border in Southern California and believed that Bennett might be smuggling drugs. A Coast Guard officer stopped Bennett, climbed on board, and, after noticing some discrepancies with Bennett's paperwork, directed Bennett to dock the boat. At the time, Bennett had an outstanding warrant for his arrest. Once the boat was docked, Bennett was turned over to local officers and taken for questioning. Customs officers then searched the boat for drugs, but didn't find any. However, Officer Malcolm Chandler found a GPS device showing that the boat had traveled from Mexico to California. The next day, the officers brought the boat to a Coast Guard facility to X-ray it. The X-ray showed more than 1,500 pounds of marijuana on board. Subsequently, Bennett was arrested and charged in federal district court with 1 count of importation of marijuana and 1 count of possession of marijuana with the intent to distribute. At trial, Chandler testified that he found a GPS device while searching Bennett's boat and that it showed the boat had traveled from Mexico to California. Bennett's attorney objected to the testimony based on the best evidence rule, but the court overruled the objection. Following trial, Bennett was convicted. Bennett appealed to the Ninth Circuit. After concluding that the search didn't violate Bennett's Fourth Amendment rights, the court turned its attention to the admissibility of Chandler's testimony about the GPS device.